Employment Law This Week. I'm George Whipple. Our top story, OSHA plans to roll back a controversial reporting rule initiated at the end of the Obama administration. The Occupational Safety and Health Administration has proposed rescinding parts of a 2017 rule that requires companies with 250 or more employees to submit detailed reports on workplace injuries. OSHA says this move would protect employee privacy and reduce the burden for employers. 3 organizations have filed suit over the proposed changes, saying the data from the detailed reports helps improve workplace safety. Corey Argust has more.
On July 25, 2018, Public Citizen, which is a progressive consumer rights advocacy organization which was originally founded by Ralph Nader, was joined by 2 other public health organizations and sued OSHA to try and seek to actually enforce the electronic reporting rule requirements. OSHA had announced that it was suspending the deadline of July 1st, 2018 for submitting the required forms and had actually stopped accepting these forms. So OSHA is now being sued by Public Citizen, who is arguing they violated the law by suspending the deadline and is now seeking to enforce the requirement that employers actually submit these forms to OSHA.
Governor Jerry Brown has signed a law that gives employers new clarity on California's salary history ban, which went into effect in January of this year. The new legislation defines terms including pay scale, applicant, and reasonable request. The law also clarifies that employers are allowed to ask applicants about salary expectations. New York City employers are now required to accommodate some employees' schedule changes. As of July 18th, employees in New York City can request temporary schedule changes or permission to take unpaid time off for personal events like a caregiving emergency. Employers are required to grant up to 2 changes per year for up to 1 business day per request. A new poster has been issued by the city. Employers take note. The current FMLA forms have gotten a short reprieve. The Department of Labor's model FMLA notices and medical certification forms were set to expire July 31st, but that date was pushed back to the end of August. Once the OMB approves new model FMLA forms, they will be valid through 2021. And that brings us to our tip of the week. Christopher Bona, a partner at Finn Partners, is here with some advice on issue management programs.
Issues management is a communications leadership function within a company that allows the company to spot emerging trends that can crystallize over time into issues that may compel the company to communicate to a variety of its key audiences. So then how can organizations be prepared and have some sort of a framework for identifying and responding to issues that might affect the business? The first thing that they should do is identify all of the issues that could possibly happen that would come up in the business that would compel the business to communicate in some fashion. Analyze those issues and prioritize them. Then take that list and create responses that are ready to go or can be adapted so that when the issue emerges and occurs, the organization is ready to respond. And then lastly, make sure to evaluate the impact of the execution of those responses to the issue.
Thanks, Christopher. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.